Let's talk about conservatorships. What are they? When are they necessary? And why should you care? Conservatorships may sound like some arcane concept, something that few people need to worry about and that fewer people actually understand, but they are more common than you may think, and understanding what they are and the impact they can have could be beneficial to you in the long run. This topic kind of catapulted into public awareness in 2021 when Britney Spears' conservatorship battle gained international media attention. Now, if you remember, Britney's conservatorship was established in 2008 after a few highly publicized incidents, like her shaving her head and hitting a paparazzi's car with an umbrella. In today's world, behavior like this wouldn't be so shocking. I mean, it's pretty common knowledge that paparazzi cross the line with celebrities on a daily basis. Plus, shaved heads are a popular fashion statement. Just ask Doja Cat, Iris Law, Willow Smith, Demi Lovato, Amber Rose, or any of the other dozens of female celebrities who have shaved their heads in the years since Britney was criticized for it. But back then, Britney's behavior was outside the realm of what people were used to seeing from celebrities, which meant it came under intense scrutiny. She also struggled with her mental health, spending time in and out of the hospital under psychiatric assessment rulings. The point is, at the time Britney's conservatorship was established in 2008, it may very well have been in her best interests. At least a judge thought so. But fast forward 10, 13 years, and it became clear that this court-ordered arrangement was no longer benefiting her. Now, it's easy for outsiders to look at situations that other people find themselves in and have all the answers, right? We can say she should have done this or she shouldn't have done that, but the truth is, once you're up to your ears in trauma, health problems, legal battles, it can be almost impossible to dig your way out. I'm not here to sit in judgment of Britney Spears. I am here to tell you how you can avoid a similar fate. You may think that someone like Britney Spears has nothing in common with you, and there's no way your fates could ever be similar. And if that's the case, why should you care about the solution to a problem that's so far removed from you? Well, because this isn't a problem reserved for celebrities or wealthy people or people with high-stress careers or anything like that. If you have any assets that you value and wouldn't want to be wasted, sold, or given away without your permission, you should care about protecting them. Incapacitation, which is essentially the standard used to determine the necessity of a conservatorship, can happen to anyone. An illness, a car accident, a traumatic event, there are endless ways that someone can become unable to care for themselves or for their finances. So, if you're thinking this isn't a concern for you, think again. I see this all the time with my clients. They want help with creating estate planning documents, but they focus on the basics like wills and trusts without realizing the importance of a power of attorney. And I get it. As unpleasant as end-of-life planning is, we know that death happens to all of us. But discussions around setting up a power of attorney can be even more difficult. None of us wants to think about the possibility that we'll be incapable of taking care of ourselves or making sound decisions at some point in the future. Something like that isn't a guarantee, so it can be easier to pretend there's no chance it can happen to you. Losing agency and control over our own lives is, for many people, worse than death. So it makes sense that this topic is often avoided. But just because you don't want it to happen doesn't mean it won't. Not planning for it doesn't prevent it. You might as well take action now to create the most secure future possible. But let's back up a little. Before we dive into how you can avoid a conservatorship with estate planning, I should discuss what it actually is. A conservatorship is a type of court case where a responsible party, the conservator, is appointed by a judge to manage some aspect of another person's life. It can be either their estate and financial affairs, or themselves as a person, or both. When someone is incapacitated and unable to care for themselves or their finances, the court can step in and say, this person needs help, and they appoint a conservator to take over. Now, this is the intention, the premise of a conservatorship, that the conservatee, the person who needs help, is given appropriate assistance. This is not always the reality, though. For Britney Spears, her conservatorship became harmful and overly restrictive. If you followed along with any of the news surrounding #FreeBritney or coverage of her hearings, you might have heard some of the claims she made about her treatment, which were appalling, from financial abuse and exploitation.
Jamie Spears obtained at least $6.3 million from the estate, from Britney Spears' work,
to excessive personal restrictions. This is not the norm. This is actually conservatorship abuse. But Britney's case shows that this type of treatment can and does occur. And if it can happen to someone as well-known and connected as Britney Spears, it can happen to anyone. I'm not trying to scare you with a big doom and gloom story, but I do want to stress that avoiding conservatorships is a good idea. The conservatorship process, from the initial filing to the final court order, often takes months. Keep in mind, these are months that you are spending already incapacitated and needing assistance while this legal process drags on. Plus, court costs and legal fees add up as the clock ticks away. Hopefully, I've established that conservatorships should be avoided at all costs. The potential for them to go wrong is too high, they're time-consuming and expensive, and they don't give you any control. But how can you have control when the whole point is to grant someone else decision-making power? I'm glad you asked. A power of attorney, or POA, is a legal document that grants permission to someone you choose to make financial and estate decisions on your behalf. A POA document is quick and easy, so there's really no reason to skip it. A power of attorney is a proactive approach, so it's something you do before you become incapacitated, which gives you control over who will handle your estate and financial affairs if ever there is a need. Establishing a power of attorney means you can maintain some control by designating someone you trust to fill in for you. Imagine 5 or 10 years from now, you become incapacitated. How is it important for this fantasy? You can use your imagination. You are suddenly incapable of making your own financial decisions, which leaves you and your estate vulnerable. Luckily, past you thought about this possibility and designated someone to step in by creating a POA. Incapacitated you gets to benefit from this careful planning. When you think about it, a POA actually allows you to take care of yourself by proxy. So, when do you need to start prioritizing this preparation? Well, now, to be honest, to keep using Britney as an example, she was young when her conservatorship began, just 26 years old. There's no age limit or time frame, no set deadline on when you'll stop being able to take care of yourself. Admittedly, the older you get, the more likely incapacitation becomes. But there's nothing that precludes young people from experiencing an incapacitating event. So, to reiterate, now's the time for a power of attorney. You have a few options for POAs that deal with your finances: general, limited, and durable. A general power of attorney grants pretty broad powers to the person you choose to act as your agent. They could manage your assets and financial affairs with the same authority as you. However, a general power of attorney is deemed invalid when you become incapacitated. A limited power of attorney is used when there is a specific area or task you want to grant authority for, but it also ends with incapacitation. Both general and limited POAs may be made into durable POAs, which are intended for use in the event of incapacitation. Since one of the most common reasons people establish a POA is for use during a time when they cannot make their own decisions, a durable power of attorney often makes the most sense.